Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. I'm going to timestamp this just a bit. This is the first week of early voting in Texas. I actually voted a couple of days ago, 2 days ago, in fact. I'm not going to tell you who I voted for, other than the fact that I voted for the one candidate in the 379th. I hope that's enough to get that person elected. You never know the way things go nowadays, but obviously I'm joking. I had a good opportunity to go downstairs. We're very fortunate in the courthouse to have a voting booth here. By the time you hear this episode, we will know who has won in the election. And so we're going to talk a little bit about that. I have a special treat for you today. We're going to go a little deep in our conversation. I'm looking forward to it. A really, really deep dive. I think those of you that have listened to Beyond the Gavel and have appreciated some of the episodes that we have brought forth will appreciate the deep conversation that we're going to have today with a very good lawyer named John Hunter. John, welcome to Beyond the Gavel.
Thank you for having me, Judge.
Thank you for being here. You want to tell our listeners a little bit about who you are?
Sure. I'm John Hunter. I'm a criminal defense attorney here in San Antonio. Been practicing for 12 years, almost to the day, and got into criminal defense just because I feel that individual rights are the most important thing about our government, and feel very passionate about that idea of trying to have a buffer between what the government does and what the people do. Before I was a lawyer, I went to the University of Texas for undergraduate and studied philosophy. I'm a big lover of especially ancient philosophy and the existentialists and those kinds of people. After college, I took a little break. I lived in Colorado and took people fly fishing, a fishing guide kind of a thing. And it was at that time period, it was like, '08? It was in the middle of the financial crisis. It was not a good time for everything.
I remember it.
I was living in, I think, Park County, Colorado, which was Forest County in Colorado at the time. And the fly shop I worked at, it was at a gas station. And I didn't know anything at the time about warrants or, what happens if you don't pay your traffic tickets or any of these things. But these people were asking me about all these problems all the time. And I just thought, oh my God, like the law is just making these people's lives miserable. And horse thievery was the most prevalent offense, I think, being charged by the sheriff's department out there at the time. When it had that nice Wild West vibe. So when I ended up going to law school, that was the path I decided I wanted to go down, was to help the kind of people that were worried about their traffic warrants at the gas station.
It's a beautiful part of the country.
It's heaven on earth.
I bet you the fly fishing was just amazing there.
Yeah, unbelievable.
I haven't had a chance to do it myself. I've been to Colorado, took my parents and kids back a couple years ago, but the country was amazing. It's something I'll never forget. I'd love to go back. And if we're ever in the same area at the same time, maybe we could go fly fishing.
Let me know. There's a great little hack, Cheeseman Canyon, the Platte River, South Platte River that runs into Denver. There's a stretch of water that the real elite people at the time, Dick Cheney, those kinds of guys, they're members of this private club. And, the fish are just, out of this world ridiculous, big fish and lots of them. And it's a wonderful time, gorgeous scenery. But there's a public access right above the club. So the fish don't care.
I went fishing a couple weeks back in the bay, Laguna Madre, middle of the Laguna, and had a great time. A lot of redfish are still out there. We had a lot of black drum, some speckled trout. I grew up in that area, so every now and then I'm used to seeing the hardhead catfish and some of those types of fish. But overall, it's a great time.
Yes, Laguna Madre is beautiful. I've fished it several times. I love it. You can fly fish for reds too, and that's a real experience. I enjoy it a lot.
You mentioned you've been out 12 years now, practicing as a lawyer. And we were talking right before we started recording. I remember when you first came out, and one of the things that impressed me about you is it was very clear that you were having fun when you were in court. Isn't that what it's about?
Yes. Yes. This is a fun thing. I mean, there's a lot of stress, and the human misery that we are dealing with is something that weighs heavy on all of us.
Yeah.
But it's fun because you're getting to wrestle with very important ideas, with very serious people.
Yeah.
And it's exciting.
Yeah, when I say fun, that's what I'm talking about, right? The idea that you could use the law in a way that would be effective for you, for your clients. You would make arguments that were unique, sometimes challenging for a judge like myself to know how to rule, because one of the best things about working as a lawyer, working in this craft, is that every day brings a different challenge, right? Every trial, every case has a life of its own. And as a result of that, we're dealing with things on an ad hoc kind of basis, kind of figuring things out as we go along.
Absolutely. You can have an issue 100 times and know the outcome of that issue almost like before the people talking to you even explain the whole issue. You're like, oh yeah, I know what this is. And then you're surprised. You twist one fact and the whole thing changes. And now it's like, well, how does that work now?
Yeah.
I never thought of that before.
Yeah, that's
the fun.
Yeah. So it's sort of like a law school class.
Yeah.
Right. Well, excellent. Well, I'm glad you're here. You've been involved in some really big cases. I know that you were president of the San Antonio Criminal Defense Lawyers Association. So I got to work with you really closely for that. It's a year term, right?
Yes. We worked together. Gosh, right. I guess it was in the middle of the pandemic that we got to work together.
That's
so
right.
much. But that was a fun time. And, I think indigent defense in the county is in a much better place as a result. I'm excited to see how that continues to grow.
I agree. And it will continue to grow. We have some excellent lawyers in Bexar County, and it was great to work together to do these kinds of things. Let's talk about one case in particular. We're going to choose one. Hopefully we bring you back in the future and talk about other cases because you've been involved in a lot of them. There's a case called the Andre McDonald case, which has really been high profile here in San Antonio. It brought forth a lot of attention when it was being tried. And then prior to that, I know that the complainant in the case of victim couldn't be found. I think it was originally filed as a missing persons case.
Right.
Now, there's a little bit of a caveat for the listeners on this one because the case is still up on appeal. Is that right?
That's right. Yes, it's still pending in the Eighth Court. The Eighth Court issued an opinion affirming Andre's conviction. We've filed for rehearing, and that's still pending before the court. So not sure how that will go one way or the other, but obviously some of the issues that are related to the case are probably things we can't talk about until that's over.
And the Eighth Court of Appeals is not the court that officially is the region that Bexar County or San Antonio is within. I know that there is an equalization docket that the appellate courts go through. You want to explain to the listeners how that works?
To the extent that I know it, yeah. So the way I basically understand it works is that if one court gets backed up or has too many cases on its docket, the Supreme Court and the Court of Criminal Appeals can issue orders supervisorily to sort of realign cases. So Andre's case would have normally gone to the Fourth Court of Appeals, which covers Bexar County and quite a few counties south of here. But because of what their docket looked like at that point in time, and I guess the spring of 2023, Andre's case and several other appeals I was handling at the time got moved. So I ended up having, at the same time, two cases in El Paso. And I never had a case out in El Paso on appeal before. And then a couple of my cases ended up in the Corpus Christi Edinburgh division at the 13th Court. So there's no real significance to that other than just, I guess a lot of people were filing appeals at that same time.
Well, you talk about the Fourth Court. The Fourth Court has 32 counties. It may or may not be, but I believe it is the largest regional area amongst the appellate courts and the courts of appeals. Courts of appeals are intermediate courts, meaning that they're the first line of appellate court. Subsequent to that, if somebody wants to appeal a fourth court decision or any court of appeals decision, it would go to either the Court of Criminal Appeals, which handles criminal cases. It's the highest court in the land for that. Or it would go to the Texas Supreme Court, which handles civil cases. So a lot of folks don't know in Texas, we actually have two Supreme Courts.
Right. Yeah. We're one of only a few states, I think, that has done that.
Interesting.
Yeah.
Interesting. And I know you do a lot of appellate work.
I do. Yeah. Probably about 50% of what I do is appellate work.
Yeah. Do you think that makes you a better trial lawyer?
I think so. I mean, sometimes I have trouble remembering case names off the top of my head, but I can remember the story and I can remember why it applies. And so like, at least lets me have, if I have a moment, I can look it up, something. So I think it's helped me better explain myself to judges than I would otherwise be able to.
Well, knowing that Andre McDonald is still on appeal, you've applied for rehearing with the Eighth Court of Appeals. There are certain things that we can and cannot talk about as it relates to this case. And so we'll be careful, make sure that folks out there recognize that as a sitting judge, I am not able to comment on any pending cases. And as a result of that, I'm not going to make commentary on any potential issues that the courts need to rule on as it relates to my own opinion. So we can point to the record. Judges can always talk about what is on the record, even with pending cases. And so situations like that, we'll make sure that we stay clear of those issues. So tell us a little bit about Andre McDonald. Give us some of the details of the case. I know that folks in San Antonio generally know what the case is about, but for those that are outside of San Antonio, or frankly, that don't pay as much attention to these types of crime stories, explain to us exactly what the situation was.
Sure. Well, Major Andre McDonald was a major in the United States Air Force. He was working with a secret clearance. He was, I think a very trusted member of the armed forces in terms of his work. Worked in a SCIF, which is like a secure area within the Air Force Base where you can't bring a cell phone in. It's mostly electronic, cyber digital type security, but extra protections that are attendant to that. And he came from Jamaica to the United States, grew up in Jamaica, lived with his mom in Florida. Over the course of his life, getting acclimated to the United States, becoming a citizen, he went back to Jamaica for a funeral and met Andre McDonald, who he brought back to the United States and married. And
she was 19 at the time, right?
Something like that. Very young.
He was like a decade older or something.
Older guy, yes. They had a family. They moved to Texas for Andre's work. Andreen was going to college and got a degree and became, in and of herself, a powerhouse. I mean, she was an entrepreneur, had set up several in-home living assisted healthcare facilities in San Antonio, and that business was doing very well. They had a daughter, lovely little girl, but unfortunately, she suffers from autism and has had a lot of difficulties with that.
The child?
The child, yes. So, that's sort of the backdrop of this. That was the McDonald's life when they make landing here in San Antonio and start building their life here. Mm-hmm. And then, a tragedy unfolds. Andreen goes missing, and there's a long period of time where she can't be found. There are, county-wide efforts to try and locate her. Andre's arrested outside of a gun store in San Antonio. Mm-hmm. And, there's a long litany about how he's held, where he's held, and under what circumstances that were all of major issue in the case. But, functionally was being incapacitated by the Bexar County officials while this search was going on. Mm-hmm. And in the course of that search, several disturbing things were found, which was a major part of the case as well.
You're talking about in the home.
Right. In the search of the McDonald's home. I can go into the specifics of that. It's kind of a long saga, but it was a 2.5-day hearing just on our motion to suppress based upon the issues related to the search of the home. But
there was a time, and this is basically from what I could glean from the record in and of itself. I did spend just a few moments kind of looking at it before we started this podcast. Andreen, who was the victim in this case, the alleged victim, obviously, was missing for a period of time. I know folks in the media had then started to reach out, or folks in law enforcement started to reach out in the media asking folks for help as it related to her disappearance. If anybody knows of her whereabouts, I think a local official was putting out that out in the air. Some folks got together, started a search party. Is that kind of what happened?
Right. There were search parties. People were using drones. Tons and tons of police reports of just random report. Officer found something in the bar ditch over by this facility. And so a deputy has to go out and look, and it turns out it's a dead dog or something. And, tons of those kinds of calls coming in. And it was a lengthy period where no one knew where she was.
When did this happen? When did all this occur?
Oh, gosh, let's see. This would have been in 2019, spring of 2019.
All right. So I can assume, generally speaking, according to the record, that investigators probably targeted in on Andre McDonald pretty quickly.
Yes, it all moved very fast, but it wasn't necessarily investigator driven. Mm-hmm. And Dreen was a very religious athlete. She did CrossFit, was sort of a gym rat type person, and had several friends, both in her industry and without, that would work out with her in the mornings. And, that was a clockwork thing. Even if she wasn't feeling good, she'd be probably in the gym. And so some of her friends from the gym noted that she hadn't made her workout. And then it was later kind of confirmed through their internal correspondence, didn't make it to work. That also seemed unlike her. And so, one of her friends goes to the McDonald residence and lets herself in the back door and starts looking around. And the couple, I guess, basically three things that stood out to her were there appeared to be some ashes in a small pile on a gravel pathway in the backyard.
Mm-hmm.
The dogs had not been let out and had gone to the bathroom all over the kitchen floor, which would be unusual.
Mm-hmm.
And there appeared to be a blood stain on the door frame or the light switch. I'm not exactly clear, but one of those places in the master bedroom bathroom area. So she leaves and she calls a friend of hers with SAPD.
Mm-hmm.
What do I do? I think that there's something wrong here. And he sort of, gives her some guidance about what to do. And functionally, his answer is to go and find Andre's mother-in-law, who lived with them at the house, and bring her back, and then call it in officially, because it ultimately was Bexar County jurisdiction, not SAPD.
So the report was made by the mother, the missing persons report.
Officially. And so, this is where when we parse the record, there will be some matter of dispute, but functionally, when the deputy arrives, he's greeted by Andrine's two friends, actually, and Andrine's mother.
Mm-hmm.
And based on their interactions, the police enter the home, on a theory of consent. Some of these things were hotly contested, and we, maintained that position. But, ultimately, Judge Castro disagreed and felt like there was, ample evidence of consent to let them into the house. And so it's an interesting question because these are all private citizens.
Mm-hmm.
And even though Andrine's mother lived there, there's also sort of a scope and expectation of privacy even in a mutually shared home. Questions about whether or not someone has an open invitation to come into your house. I have several friends that have a key to my home if I have an emergency, but I wouldn't want them to go into my house at, just at any given point because they might be concerned about me or because they can't get a hold of me for a couple of hours. But
that's an interesting topic. So unrelated to this case, let's talk about how that kind of stuff works,
Sure.
right? Are you talking about consent, third-party consent, who lives in a house? How does that work? Can you explain to us, generally speaking, let's say a police officer wants to go in somebody's door, interview somebody, look at something, they don't have a search warrant, they knock on the door, and let's say maybe a roommate opens the door or somebody's mother opens the door.
Right.
What are some of the legal things that you're looking at?
Well, we're looking at whether they have an equal right of access to the area police want to search or not, basically. And in the absence of an equal right of access as an objective question, like literally, if we were to check it out, their name would be on the lease or their name's on the deed or they're married to the person or something. Then the next question would be, do they have a parent authority to grant that consent, even if it may not be an actual fact that they have equal right of possession? So that's kind of where most of those cases boil down to.
And so if the police knock on the door, somebody says, I have the right of possession, I have the right to give you consent to come into this home and look at certain things. If the police officer believes it, because it is apparent to the police officer that this person has access, let's say that they're the only ones present in the home at that time, and they're mistaken later, is that okay?
If it would have appeared to an objectively reasonable person that person would have had the authority to do it, then generally courts are going to say, look, the officer is doing the best he can with what he has, right? He's using his five senses the same as everybody else.
Right.
He's got, hopefully the faculty and logic to make these reasonable inferences.
Right.
And just because it turned out not to be true isn't really the controlling question. Then you have to really get into the meat of, okay, well, is it objectively reasonable?
Right.
Someone who says, I'm his live-in girlfriend, I've lived with him for 10 years, I have a key to the house, come on in. Sure, like if it turned out that wasn't totally truthful, it'd be hard to say the officer made a mistake. If a 6-year-old answers the door, or if, the person who's been burglarizing the house answers the door and he has no idea who lives there or anything else about it, well, then maybe it's not objectively reasonable.
So it's all based on the fact finder,
right?
Being the judge or being the jury. How reasonable is this? Which is very case specific. Right?
Very, very.
And a lot of times you talk to people, I meet people all the time that say, how does this work? And they go into the explanation and then you say, it's all very case specific. It all goes down to every single minute detail of that particular situation. And then it depends on what the judge or jury believes actually happened and what is fair, what makes sense. They take everything into balance. Very interesting.
Yeah, I know. That's what we were talking about earlier. It's that sort of infinite number of combinations, even though we know how many numbers are on the dice, how many cards are in the deck, like how they get shuffled is really how it all shakes out. And that's what makes it fun.
Yeah, that's the interesting part of the law. Right. Having to decipher those shades of gray and figure out where exactly the argument is going to flow. making that argument. And that's the fun that we talked about earlier, right? It's almost like being like you're trying to solve a puzzle, which is non-stop, non-ending.
And that is always changing. And that involves, not pieces, but real human beings who do all sorts of things to kind of muddy the water further.
Yeah. So you had that kind of an issue on the Andre McDonald case?
Right. So there are multiple search and seizure issues, but that's sort of how the story begins. And that's the first set of search and seizure issues. And the deputies come, and Andre arrives at the residence while the deputies are there shortly after Andrine's friends and her mother get back to the house. The testimony was that what they called that SAPD detective having left the house and then returned to it with the mother. And, they're talking with Andre about the circumstances and why they're concerned and so forth and so on. And so Andre gets in his car and he leaves and he goes to a hospital. And he asks if there's anybody named Andre McDonald there. And the clerk at the front desk of the hospital says, yes, there's a woman named McDonald here at the hospital. And, there's I think a child with her, maybe.
Room 3, right?
I mean, it was
like that.
It was very strange, especially in light of what we later learned. That was a very strange coincidence. But Andre gets that information and he walks out and he goes back to the house and he, tells the deputy, she's at the hospital. I just checked. The deputies don't take his word for that. They detain him. He sits in a squad car for several hours. They search the house pretty thoroughly, photograph it extensively. Every nook and cranny, I think, of the house was pretty heavily photographed. Eventually, they decide she's not there. There's not really enough evidence of foul play to make an arrest. So they turn the scene back over to Andre and he spends the night in his house. The next morning, an Air Force superior, forgive me, I'm not very good with the ranks in Air Force, but someone above Andre in rank comes to check on him. And they have a discussion. Andre's phone has been seized during that initial encounter the previous day. So, they're talking about, places where he could go to get internet access, public library, how to get a landline, those kinds of things. And they leave. And shortly thereafter, Andre's trying to leave and he backs into his garage door and causes significant damage to the garage door. So then he reaches out saying, hey, do you guys know a garage door repair company? Back to these Air Force officials. And so I think there's some exchange of information that way. They've got phones. They look that stuff up. And Andre departs. One of the major issues of contest was we have, by this point, Bexar County has unleashed a lot of people in this effort to find her. I mean, we're I guess, in the 24-hour, maybe 30-hour range after it was initially noted that she's disappeared. But there's a Bexar County Sheriff's Department mobile task force trailer set up, to coordinate search efforts. And there's surveillance that's been ordered on Andre McDonald. And there are different teams that are working in coordination to try and figure out what's going on and to keep an eye on Andre while it's all going on.
Investigators are watching him at this point.
Well, and this is one of the big issues that was debated hotly. There's so many patrolmen and so many different groups of people within Bexar County working on it that it was difficult to sort of ascertain, like, where every single car was at every given time. But it's a gated community, and Bexar County Sheriff's Department has a code to get in the gated community. So we know that BCSO officials had entered into the gated community before Andre left, and ostensibly were watching him and would have seen that he had damaged his own garage door and would have watched his superiors leave the residence. But at any rate, the surveillance is now mostly focused on following Andre's whereabouts. And he goes to Nagel's gun shop over on San Pedro, where he is ordered to be arrested. But meanwhile, back at the ranch, the sheriff's office has dispatched members of it's like a community policing unit. And they largely assist with functions that the sheriff's department is hosting. They, help Javier Salazar with various, public relations things around the city.
That's our sheriff here.
Make sure, exactly. Yes, he's the elected sheriff here. Long story short, they're not sort of plugged into the normal apparatus of law enforcement. Some of them are retired from that function, and this is sort of their last operational participation with the sheriff's office. That team is called out to go and do a welfare check on Andre and Andrine's residence, and they see this damaged garage door. And so they enter the property through the damaged garage door, and they observe a shovel in the back seat of one of the vehicles that was left at the property.
So is that any kind of, now, not talking about this case specifically, but generally speaking, if police officers arrive at any scene and they see some way to get in that doesn't require them to knock a door down, is that generally something that is acceptable?
No. I mean, the Fourth Amendment protects persons, not places. But within that little mantra, we all understand that certain places where persons go are more sacred than others, right?
So let's say a window is open in a car, right? And the car is parked in a parking lot. Could they stick their hands in that car through the open window and grab some item that is in the vehicle?
Well, now it depends on what the item is. Okay, so with homes, the issue is pretty much you need a warrant to enter a home. Whether that door is open, whether that window is open, it doesn't matter. Absent some really carefully narrowed exception, you can't go into somebody's home as a police officer just because you think something's hinky.
That's your castle.
That's right. Even if you have probable cause, I mean, it could be, I'm growing marijuana in my house and, I'm admitting it freely, and the police now have probable cause to go in. They still need a warrant. Like that alone would not be enough to justify their entry.
And generally that's because there's no emergency, right? If you're growing marijuana, it's not like you're going to instantly flush it all down the toilet and you're going to get rid of the evidence.
Right.
Right.
Right. At least you hope. I mean, Kentucky versus King made everyone nervous for a while. But yeah, no, I mean, so that being the default rule, you mentioned an automobile. An automobile is a little different because we've got this automobile exception that basically says because these are transitory, movable things and they don't necessarily stay in one place when we need them to, officers really don't have time to get a warrant for that. So as long as they have probable cause, then the officer can search a vehicle without a warrant. Now, I just, that ACLU streak in me says, oh my God, that's evil and horrible, but it's been the law for so long that there's really nothing we can do about it. It's one of the most well-established precedents of the 20th century. So
yeah, and incidences where a vehicle is inside of a garage. Now you're talking about sort of a double analysis as it relates to
right. And I mean, the fact that the car is within the closure of the home, I think pretty well settles that this is a home search, not a car search. But the car's got windows and it's transparent, and so if the officer is lawfully in a place to view something that's either evidentiary or contraband in a car within a garage, then that's called plain view.
Right.
And that isn't a search at all, right? What you can see with your naked eye from a vantage point you're lawfully allowed to occupy, that's just your province as a human being. It's not a search.
That's why police officers have the ability to look over the fence, let's say, into somebody's backyard and view things and report on things.
Right. If you had that marijuana plant growing in your house and you opened the curtains and it was just visible from the street and the officer's walking by, well then, okay, the officer didn't do anything wrong in observing that. It can now use that as probable cause to go get a warrant.
Really, you can take the example as far as you want. Or I think about drones. Or I think about satellites in the sky or some sort of heat technology that some law enforcement agencies have now where they can look through a wall and can tell if somebody's on the other side.
Yeah, well, that was the case. I think out of California, and Judge Scalia wrote the opinion on it. And again, we were laughing about this earlier. I can't remember the name of that case to save my life. But what they said on those kinds of cases is if the technology is enhancing your sensory ability beyond what a normal person would just have, then it does come into the world of being a search. And the Fourth Amendment is implicated, and now we have to do all the analysis of it.
What about like a dog sniff? What about something?
Dog sniffs have been held not to be a search as well, but it depends on where the dog sniffs, right? So like Florida versus Hardiness, the issue wasn't that the dog was just outside this person's home and smelling around and he alerts. And there's nothing inherently Fourth Amendment implicating about the dog sniffing, but they let the dog onto the man's property. And so the court talks about, you have like the actual clothes of your house, like the four walls and the ceiling and everything. And then you've got the curtilage of your home.
Right.
So like your front yard, your backyard, and then the court got really, really tangled up in the weeds about things like implicit licenses. A door-to-door salesman can trespass temporarily on the curtilage of your home to knock on the door.
Yeah, you're walking down the sidewalk, right? If you're
right, but the idea of running a dog along the perimeter of the home is a little bit more intrusive than the door-to-door salesman.
Right.
So I mean, homes are just real sacred. I mean, it's one of the few. If you're watching the Supreme Court, if you're interested in Fourth Amendment law, and you see a case involving a residence. I'd say the chances that they're going to rule in the defendant's favor and find that that was illegal go up, maybe like, 2/3 more. It's a much higher probability that they're going to rule in the defense favor if it's a home versus if it's a search of a person, search of a car.
All right. So now we know that cars don't have the same protections.
Right.
And so it's always amazing to me that people get caught driving somewhere and they start talking about their rights, and police officers having an inability to get into their vehicles. And I'm thinking in my mind, that's not quite how that works sometimes.
Yeah, no, that isn't how it works in the real world.
Yeah. So then, according to the record, they found these items in this vehicle.
Right. Well, they used the discovery of the shovel to go and apply for a second search warrant. Mm-hmm. And I guess I should clarify, because I didn't before, when they, on the first day, when the friends came and they called the deputy, eventually BCSO goes and gets a warrant for the same, subject matter as what they've already seen by the consent of the mother-in-law. And that is a belt and suspenders approach, and is oftentimes done in situations where the police may have some concern that, maybe what they did was legal, but maybe it isn't legal. Let's just go get a warrant. Uh-huh. If something's illegal, you can't use what you observed illegally to go tell the magistrate in the search warrant, please let me have access to the home, because now you've used a Fourth Amendment violation to commit another one. Right. But assuming everything's kosher about the reasons why you developed your probable cause, best practice to get a warrant for a home. And so they do that again on the second day based on the discovery of that shovel. And so then the question becomes, well, we have already done a search. We've done an extensive search of this premises, and we're going to go back to the same place less than 24 hours after the fact. And the only difference is now we have a shovel in the back of a car. Like, does that add enough of an additional grain of sand onto the scale that we get another warrant?
That's an interesting question.
And so that was an interesting question in the case too. And just a fun thing, it didn't come up in this case. That this is something that, without dispute, they did correctly, but it's good if any of your listeners are criminal defense attorneys, or if they're in law enforcement and they want to make sure that they don't make this mistake. Mm-hmm. If you want to search the same property twice for the same subject matter, basically, the second warrant has to be signed off on by a district judge or higher. Uh-huh. You can go to a justice of the peace or a county court law judge for the first warrant. Even though they may not have jurisdiction over what eventually you find inside the house. Right. But because that second warrant could be subject to greater abuse, you could get a warrant every day for somebody you really didn't like. Yeah. We want it to be reviewed by a district judge or a judge in the appellate courts.
And there are certain circumstances where district judges or appellate court judges are required for certain types of warrants. For example, we talked about this in our last interview, phone warrants, right? Phone warrants, not necessarily phone, but more of electronic type devices where somebody can go through your entire personal items, every single thing that you keep on your phone that relates to what you do in your life. That has a little bit of a higher degree of protection.
Yes. I mean, that's, and I think that's where the case law is going. Yeah. It's still kind of in its infancy. It wasn't, was it 2014, 2015, where the Amarillo court for the first time just came out and said what everyone knows, you shouldn't be able to search a phone without a warrant incident to arrest. It's not a pair of pants. This is your whole life.
Yeah, it made it different, right? And that's a case that ended up going up to did that go up to the U.S. Supreme Court?
That one definitely went to the Court of Criminal Appeals, and I believe got affirmed, so affirmed the reversal that the Seventh Court gave it. Riley versus California, I think.
Oh, that's the Supreme Court
case.
That's a Roberts decision that basically said the same
thing, right? Yeah, exactly.
John, I'm enjoying this conversation.
This has been great.
Yeah. Let's do a quick Q&A break.
Okay.
We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at BeyondTheGavelPodcast.com.
Welcome to the Q&A break. We have a question. How is a breathalyzer viable in court when it is arguable?
Well, I mean, if those are the only factors given, then I'd say it just shouldn't be allowed in court. It's the 702 analysis, right? So it's a scientific test. And so scientific testing can help a jury and make a good decision. Yeah. But it's got to be reliable evidence. We can't just, it's seen in The Wire where they put the guy's hand on the copy machine and they press the button and it comes out lie. It's not that. It has to be something that's robust. And so with breath testing, there is a debate that I mean, certainly I have taken a position on because of what I do for a living about how accurate they are generally and whether they should be as well regarded in courtrooms as they are. But it's not necessarily because the underlying science is flawed, right? The test the judge has got to go through is this a scientific inquiry at all? Does it involve something that requires specialized technical knowledge? Are the principles that are underlying this method valid scientific principles? Are they scientific laws? Are they well-established 200-year-old theories?
Accepted, right?
Accepted in the community. Yeah. Are the methods being employed to apply those principles deemed to be correct? Have they been shown to actually work? Is there, right. And then lastly, did they do it right? Or did, they put chewing gum in the machine or something? And those are the tests the judge has to go through. So, when we say it's arguable, most of the time, the reason that a breath machine's not really that hot, or at least that the defense is going to argue it's not that great, is because there's a lot of variability. You're basically creating a water vapor, a liquid vapor in that machine that's being read on an infrared spectrum. And from that, an understanding that I think it's Boyle's law, but I don't know. The basic idea is that the alveolar deep lung air that you're respirating will have an alcohol concentration that is comparable to the liquid blood that is in the surrounding tissues. So it should equalize out in your lungs as you breathe and you blow into the machine and Bob's your uncle. But there are a lot of variabilities. Like different people have a different coefficient for how that transfer from liquid to gas in their lungs occurs.
Everybody's body is different. Right?
Everybody's body is different. Some people have really long lungs. They say like, wow, your torso's long. You must have long lungs. Doctors, they say that to me. They're always horrified because I smoke cigarettes, but my lungs sound good. Some people don't. Some people have, either serious conditions with their lungs or they just don't have that kind of depth. So there's a biological component. And then you have the machinery component. Did you clean the mirrors on the interior of the machine? Is that concentration of the control sample properly mixed so that we know what we're expecting to see as a reference for the infrared? And those are human error things. And the way that breathalyzers work, you have somebody who's a supervisor who is going around and servicing all the breathalyzer machines in a given city or county, and they're putting a new aqueous solution for control in every now and then. They're running tests on it to make sure it works. But there are large periods of time where the only person who's interacting with that machine is a police officer who may have no scientific training whatsoever. They've been told that if they make the person blow into it and they press these buttons, then they'll get their result. And that's all they're concerned with. And so there's some unscientific things about the way that it occurs in practice that make it concerning. And it's part of just the general problem with how do you manage a criminal justice system in a large metropolitan area with this many people. And it's a balance that's hard to strike.
Part of this question, analyzing breathalyzers and whether they're viable in court and whether they're arguable or not, to me relates to any evidence, right? All evidence, depending on testimony, any evidence related to whatever comes in before the jury is always arguable, right? There's no such thing as a black and white piece of evidence. I mean, you could say, yeah, this article of clothing was found on the body, but where's the evidence? You could have a photograph. It's still up to a jury to make a determination as how credible that evidence is. So even if you make an argument that a breathalyzer result is something that should show somebody being intoxicated as a fact, it's still something that, based on everything that you're talking about, as a piece of evidence, still must be something that considered by the jury, still must be something that is balanced along with all the other pieces of evidence to come up with whatever they think is a fair result. Lie detector tests, you mentioned that earlier, lie detector tests are not reliable enough for a jury to be considered.
Right.
So the idea is, if it's reliable enough, right, there's a certain standard that must be met for the judge to allow the jury to view it or consider it. Then the question is, how reliable is it to the jury to make the ultimate determination that they need to make with their verdict?
Exactly. Yeah. Breathalyzers are fairly non-controversial at this point. I mean, what I'm sure what you have to deal with more than anything is that third prong. On this occasion, did the officer use it correctly?
Right.
So that we can allow it to come into evidence?
That's right. Yeah. That's right. That's an interesting question. We can talk about that one for a long time.
Yeah, that's fun.
Thanks for sending those questions in. Keep them coming. Head over to beyondthegavelpodcast.com to send in any other question that you might have, something that we would love to answer. Let's get back into the show.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back to the show. I'm here talking with John Hunter.
Good to see you, Jeff.
So going back to Andre McDonald, so then they collected some items from the home?
Right. They collected quite a few items that would be troubling. A couple of pails of gasoline, shovel.
Some sort of axe, right? And that was in the,
Yeah.
I saw something in the record about finding some receipt and some trash can.
And we suppressed this receipt. So that's the interesting thing. I mean, and I can talk about it because one, it's public record. Two, it's on the record. And three, KSAT broadcast the whole motion to suppress. But when he was arrested at Nagel's, there was a shopping list that sort of tracked the items that were found in his garage that would be consistent, perhaps, with, among other things, disposing of a body. Trash bags, I think a hatchet, rubber gloves, those kinds of things. And then, there's also discovered in a trash can some things like a hammer. And the hammer is very significant because ultimately the serology on the hammer came back that there was human blood on it, and Andrine's blood was on that hammer. So, clearly that was, I think, their leading theory for how she died was that he killed her with the hammer. And that, I think, was their position all the way up to trial. So the physical objects were recovered, but the receipt, the document that was in his pocket wasn't. The takedown at Nagel's was pretty aggressive. The footage was admitted into the record. He was, tackled, body slammed into the ground outside of Nagel's. He didn't actually purchase a gun at Nagel's. He was at the counter. He paid for a gun. They're waiting for the background check to come back, and he just leaves, and he's taken down to the ground. And then he was booked into county, but then immediately transferred into Air Force medical custody on some kind of a psychiatric hold, which implicated something called the Boxer Law, which is sort of a complicated thing we don't need to go into. The judge agreed with us on this, so that didn't come in.
So that kind of raises issues like the dual court system that we have in the United States, right? We have a different system for state courts and a different system for federal courts. Somebody involved in the military, then they would be subject to both because the military would be considered to be a federal type jurisdiction.
That's right. I mean, and so military is federal, and probably from a sovereignty analysis is the federal government. But basically, it's a third system, right? They have their own courts of justice. They have their own, I guess, their court-martial proceedings, things like that.
Yeah. So because of that, theoretically, the Air Force could have charged Mr. McDonald with a case. We won't say what kind of case it would be, but there would be some federal statute which they could potentially find, charge him for the exact same act in each separate system, and it would not be a violation of the double jeopardy clause.
On the jeopardy ground, you're right. Yes. I mean, I think there are other factors at play why that would be ill-advised. And obviously, from my perspective, I would argue pretty harshly against any attempt to prosecute him again.
There's something in the record that indicates that somehow or another he called somebody, some family member, and told them that it was all accidental.
Yeah.
Right? There was an accident that occurred.
Well, let me give you a little bit of backstory for this, right? Because this is one of the weirdest things that's ever happened in my career. So
that says something.
I was, there's been a lot of colorful and interesting people, but this was a wild one. Just so we're clear, the lead counsel on Andre McDonald's case is a lawyer by the name of John Convery, who's just a legend. I mean, wonderful, amazing attorney.
Yes.
And John has been working this case since 2019. I mean, very diligently, putting tons of time into it, and he preserved a beautiful record. And John was preparing for the trial, and between COVID and all these other issues, we end up with a trial in 2023 for a 2019 case. And John asked me to second chair it, but that happened sort of as a personnel shift because a woman who's been working for me, Zoe Russell, was helping John with that case. And Zoe was expecting a baby. And unfortunately, the trial date came at a point where that wasn't going to be a feasible possibility. And so I was asked to sort of fill in. And I didn't know much about it. I'd heard a lot about it. I've talked to John a lot about it in the past, but always just sort of casually like, oh, how's that case going? So when I came onto it, the two things I'm most grateful for is John had great long-term vision for how this strategy was going to play out and the motion to suppress primarily, because no one could foresee what was going to happen after the motion to suppress. But I'm sitting there and I'm just thinking, oh man, this is a fire hose. It's a lot of material to go through. So my main focus was the motion to suppress, right? That's something I could sink my teeth into. These Fourth Amendment issues happened over a span of days, both the things we're talking about at the house and then later with his phones being seized after they found Andrine's remains. We go to trial. We have our motion to suppress hearing, and it takes 2.5 days. We won one issue, we lost a lot of the things we're counting on winning. We were all operating on the belief that we were trying a case based upon a bad investigation and a lack of proof beyond a reasonable doubt. No one knew exactly how she died. The circumstances of her death were very ambiguous.
Yeah, the record indicates that her body was found, or some skull was found in a field or something.
Right. A rancher out north of town was going to collect some cow bones. I think maybe, to hang a cow skull up at the house or something. And among the cow bones, he found human remains and called the police. They were skeletonized. And so, there were efforts in recovery there. There were problems with the way that they recovered the remains. So, I mean, there were lots of interesting issues that made it clear to us that there wasn't on its face proof beyond a reasonable doubt that Andre did anything, right? I mean, she could have, and there's some backstory there. Andreen was having an affair with a guy in Jamaica who had a reputation of being a drug dealer, a rough customer type character. That had been a source of conflict in their marriage, but it had also been a possible alternative perpetrator because there were all these unusual things going on in the McDonald's lives and in relationship to how Andreen was going back to Jamaica periodically. Our focus was just, prove it. And then we have the motion to suppress, and we learn that Andre has called his mother-in-law and his sister-in-law and told them that he had an argument with Andreen over money, over a financial issue. Andreen had been moving money out of one entity that Andre and Andreen jointly held and putting it into another legal entity without his knowledge. And he learned about it when they went to go sign their taxes that night. He says, I'm done getting a divorce. He goes to cool off. He comes back. They have an argument. She says a lot of really offensive things to him in the Jamaican patois, and a scuffle ensues. And she comes at him and he throws her to the ground and he gives her a kick and he gives her another kick and he has killed her. That wasn't what he was expecting to come into. Their child, a young child suffering from autism, comes downstairs. He's concerned that she might have seen this fight. He tries to settle her back down and then he panics and he takes the body out and tries to dispose of it. The fact that all of this was coming to light, this is the first that we'd heard about it. I mean, this is something that and when I heard it all, I thought, okay, well, we're probably going to need to negotiate a plea offer. And
because there's some sort of admission there, right? That's the idea.
Yes, the account he is telling us is an account that could easily be not a crime, could be self-defense, could be a lesser crime like manslaughter, or it could be murder. And that's for a jury to decide. And we're sitting there and we're thinking, man, this is just crazy that to this day, it remains the most shocking, crazy thing I've ever had to contend with in a courtroom ever.
Well, that reminds me of the Casey Anthony type situation, right? Casey Anthony case. And for those that don't have too much familiarity with it, the Florida case, a child was missing for a period of time. I don't know how the child was very young, I guess 6 years old, something in that range. The police couldn't find the body. Casey Anthony was a young mother, was seen doing some off the wall kinds of things after the body had been reported missing, but couldn't be found. They ended up finding the body on the property that she lived in with her parents' backyard. It was a sizable estate. And the issue there is murder, right? Or manslaughter. Is this a situation where she knowingly and intentionally committed this act that ended up with this child dying, or was it some sort of accident? And that's a big deal as it relates to defenses, right?
Sure.
Yeah, because if you have an intentional knowing act of murder, then that's obviously a certain type of mens rea or certain culpability that somebody has in terms of what they're intending. But a manslaughter is based on reckless behavior, and recklessness is not necessarily something that somebody intended the end result to be. Right. And so that sounds like something similar to that. And the interesting thing about that Casey Anthony case is that the prosecutor immediately came out, said that he was going to seek the death penalty, which was knowingly and intentionally killing this child that was under a certain age at that particular time in Florida. But the issue was, how could the state ever prove that she knowingly and intentionally killed that person,
right,
that child?
Especially to that level of satisfaction.
Right. And so when the verdict came back, people were shocked. Oh my God, she was found not guilty. But the prosecutor could have opted to charge this lady with a lot of other types of charges. And some of them could have been first-degree felonies for all we know, right?
Right.
Here in Texas, we have something called injury to a child, which results in death. That's a first-degree felony. And there, you don't necessarily have to show that somebody intentionally knowingly killed a person. Is that kind of the issue then that was raised with your?
Well, I mean, yes and no. The way that Andre gives the account of it and the way he testified, I think that there's a good argument that this is not, any legal culpability, right? It's a mutual combat. They're fighting both verbally and physically. And Andreen is not some wilted flower. She's a very athletic, very strong person. One of our exhibits is a video of her giving Andre a piggyback ride, just running around the house. I mean, very, very strong woman, and could easily have held her own. I mean, and there was lots of testimony that sort of laid out this was not someone who was going to just take abuse lying down. So you have this mutual combat situation, and consent is essentially a defense to a assault in Texas, right? I mean, and there are limitations to that. People that are fighting and both people are of the same opinion. Yes, we're going to square off and have this fight. There's nothing criminal about that.
So you don't necessarily have to be in a bar and say, let's take this outside.
Right. So, I mean, there's that component to this that is significant, but I mean, it's the advice that everyone should receive when they sort of go out into the world. It's the advice my father gave me about conflict, which is like, look, you may think that you can, talk your way out of it, or you decide you want to go out and square off like men and have a fist fight outside the bar, and it's all fun and games, but sometimes people just die, right? You hit them and you hit them in the right place, and that wasn't what you were planning on, but they have a brain aneurysm, or they fall and they hit their head on the pavement and they die that way. And, violence can have unintended consequences.
Yeah. And the end result, the charge, is based on whatever the result is. So you had a jury trial, you had a jury verdict, jury came back with?
Not guilty on murder. And then found him guilty of lesser included of manslaughter. Like you were talking about, murder would be an intentional or knowing killing. Manslaughter is a reckless killing. The jury did get a self-defense instruction, but they necessarily would have rejected that to have found him guilty of manslaughter.
Right.
A couple other charge issues that were in play that are interesting, but maybe for another time. That was an interesting outcome.
And he was found guilty of something else too, right? Something that was a lesser charge.
He had been indicted on another charge previously because there was this big gap. He gets formally charged with a tampering with evidence case.
Right.
And that sort of is holding him to bail during this period where no one knows where Andreen is. So, the case arises in the spring, early spring of 2019. Andreen's not found until that summer, I think in July.
So tampering with evidence is a state jail felony?
Yes.
Okay. So then he was charged by indictment.
Actually, don't quote me.
It could be a third degree?
It could be a third degree.
Okay.
I'd have to.
So he was charged, it kind of depends, right? So he was charged by indictment of these two cases. It was one indictment with two counts?
Two indictments.
Two separate indictments. And you tried them at the same time?
No, we only tried the murder case, and then we negotiated a plea agreement on the tampering case that preserved our right to complain about the same issues on the motion to suppress.
Right.
But in the event that we were unsuccessful on appeal, would have sort of locked him into a specific sentence.
And so folks know, right? So you made that agreement because you had filed those pretrial motions that were heard before the agreement. So those were preserved for appellate purposes.
Right.
So here's an issue. Not necessarily, again, don't want to point to this case, but just generally speaking, folks maybe could hear about that case, could hear about another case. We've had it happen oftentimes in court where there's a jury trial, a jury gives a sentence. Let's say we had one not too long ago where a jury gave a sentence which was quite low, well below what the plea bargain offer that had been made by the state, and the individual filed an appeal. So with an appeal, it's not very common. They do happen on occasion, but you don't generally get a reverse and render, meaning the appellate court finds some sort of legal error. They're going to reverse the conviction, and rather than send it back to the trial court, they'll render
acquittal. Yeah,
exactly. And so
that's the holy grail,
but it doesn't happen very often. It's very rare, right? Yeah. So as a result of that, generally speaking, somebody is successful in an appeal, they go back to the trial court and you have a whole new trial.
Exactly.
And so why generally would somebody want to file an appeal when folks would look at it and say the end result was such a good result for the defendant that you would want to take that risk of retrying it, maybe getting a life sentence?
Sure. Well, he's been acquitted of murder. So from that perspective on the jeopardy clause, that judgment can't be undone. The Court of Appeals can't reverse an acquittal.
Right.
So that's not up for review. So if he were to go back to trial, murder's off the table. And the question is then, can we try this as a manslaughter case? And I think that while it's a very circuitous way of getting to the goals that we're pursuing, I think that it's a better way, right? If you're asking a jury to assess, is this murder? Is this manslaughter? Is it a negligent homicide? Is it a not guilty? Well, then there are just all these options, and people are going to come in with different perspectives to deliberation. And some might think that let's walk him, he's not guilty. And some might say, oh, he did something. I don't know if it was murder, but look, we got a lot of choices here, guys. Let's compromise. Let's figure something out. At least this is how I imagine it, right? We can't go back and listen to deliberation.
We always wish we could, right?
Yeah. The idea in my mind is, look, let's have him fairly considered on what it may be and what it may not be, right? This case, based upon what we know, based on what the evidence indicates, I think is a case where there's a debate that he's not guilty of manslaughter. Obviously, prosecutors going to disagree and try and present their case to a jury, but at least that way, the jury's evaluating a more realistic set of options. This is what the charge is. It's now reckless killing. Is he guilty of that? Is he not? How do you weigh self-defense in the recklessness environment? You're no longer debating the intentional and knowing.
Right. So you're not splitting the baby.
No splitting the baby, no horse trading.
Yeah, and then at the same time, since he was found guilty of the lesser included offense by a jury of manslaughter, then that means murder cannot be retried as a charge because of the double jeopardy issue. And then manslaughter, it's my understanding that the jury assessed 20 years, which is the max for manslaughter.
He got 20 years, which is the max for manslaughter. He went to the judge for punishment. Now, this is an interesting issue. You got to understand, at the time that we were making our election of punishment, which is at the very beginning of the trial, we didn't have any indication that there was going to be a statement of Andre McDonald in the record of any kind.
So it changed.
And this was a beyond a reasonable doubt case. And so one of the issues we took up was, we said, look, we filed that, we picked a jury, then we had our motion to suppress, and then we came back Monday to start evidence. And on that Monday, we said, a lot's changed over the weekend. And we originally filed this election for judge punishment because we thought that if he was found guilty, the only question would be term of years in prison for murder. And, with 5 to 99 or life, that would be the discussion. And we thought that a judge with as much experience as judges have, with as much perspective and knowing that while murder is always a horrible crime, there are degrees of murder. There's a hierarchy of murderers.
Every murder is different, right?
Every murder is different.
In every way. Yeah.
And in every way. But look at, from an offender-based perspective, we thought that he compared well to other people similarly situated if he was found guilty of that. But now that he was, charged with manslaughter, or now that manslaughter was on the table as a potential jury instruction, we're like, look, if he gets a manslaughter, he would be entitled to be considered for probation potentially. If there's no deadly weapon finding, which wasn't a foregone conclusion at the time. So we would like to change our application. We'd like to put in an application for probation, and we'd like to change our election. We thought that the jury might be more amenable to that if they thought he was guilty of manslaughter. That didn't work out. That was overruled. We did get to put in an application, but there ultimately was a deadly weapon finding, and that's another issue I can't talk about.
Yeah, and so back in the day we called those 3 Gs, right?
Right.
Certain offenses, which could include something could become aggravated based on the manner and means that somebody was killed, and so as a result of that, only juries can actually give probation once there's a conviction.
Right.
And so that was the idea at that point.
That was the idea.
That makes sense.
So we're trying our best, but that part didn't work out. So yes, he got 20 years and then some additional time for the tampering case.
Here's an interesting question folks ask me all the time, and I have my thoughts, but obviously we're talking to you, so I'd like to hear what your take is on it. When you have to make the election, right, when there's a jury trial yesterday we started a jury trial in this court. We're in the middle of a murder case now. Obviously, there's nothing I can say about it, but before the trial starts, before the jury walks in, you have to make an election of punishment. You got to make a determination if and only if a jury finds the defendant guilty, then this is who we choose to do the sentencing, either the jury that heard all the evidence in the guilt-innocence phase or the judge.
Right.
What are some of the things that you look at in determining what choices you make on behalf? Well, your client makes them, right?
Right. Ultimately, I'm a bit of a wuss. I punt this to my clients a lot. I try to give them a general layout of it. I mean, the things to overarchingly consider are, what are some of the themes of this case? And right, we're imagining, for the sake of this conversation with the client, everything has gone bad. And the 12 people in that box have rejected your defensive theories. They've found evidence was amply enough to prove guilt beyond a reasonable doubt, they probably don't like you that much. Keeping that in mind, what are the real overarching themes of this case, and what about this particular person makes him human?
I mean, in general, I think folks on the jury tend to look at these things and put themselves in whatever the position is of either the victim, the complainant, or the defendant. DWIs, you always hear that, they're but for the grace of God go I mentality, where jurors are thinking, to DWI, maybe somebody's thinking I didn't get caught that one time, and maybe somebody made a mistake. Or you look at things like burglary of a habitation, which is in our system, it's a non-aggravated felony,
right?
But you're talking about somebody's house being broken into.
Oh yeah,
and that scares people.
Yeah, nothing upsets people worse.
Yeah,
I think, than that idea.
Yeah, so for a judge, you're looking at those things. This is general, right? I'm not talking about anything specifically, but a judge would theoretically look at it and say, second degree felony, non-aggravated, nobody got injured, nobody got hurt, nobody died. We've seen so many of the other things that this would not necessarily be the most harshest of offenses to sentence somebody to.
Right. Exactly. I mean, at least that's the hope. I mean, and I think you can split these hairs 1,000 times down. I mean, there will be a judge somewhere out there who says, yeah, but just because he didn't do something violent when he broke in this time doesn't mean he won't do something violent next time.
You never know.
Let's hammer the guy.
Yeah.
I mean,
you never know what a jury's going to do. You never know how a judge is going to look at things.
That's right.
Yeah. And of course, as a judge, I always keep mum. I never want to give any indication as to where I'm going up until the time I have to deliver the sentence. That's the right way to be, I think.
I think so. The feedback in sentencing is just a very hard thing to process for the lawyers. I mean, there are some judges who do. They give feedback sort of as the sentencing unfolds, and it's helpful, I guess, in the sense of like, okay, I'm not going to waste my time on this. He obviously doesn't care about this one. Let me pivot over here.
Mm-hmm.
But sometimes it creates this awful sense of foreboding. And sometimes you read it wrong. Like you think, oh man, we're going to get hammered. And then the judge is very lenient, or vice versa. So I think letting the lawyers just try their case, letting the lawyers just sort of let it all hang out, probably is the best way to go, because you let it develop organically.
Yeah. One of the things I've learned is that as a judge, you should never truly make up your mind on anything until it's over, until you've heard all the evidence, because you never know. That last piece of evidence that somebody tells you may be something that is a determining factor.
Yeah, absolutely.
You just always have to keep an open mind.
How many conversations have you had in life where you were talking to somebody and you think, man, this guy's really, he knows what he's talking about and he's trying to sell me this and I think I'm going to buy it. And then the last thing out of his mouth, you go, aha, I caught you.
It happens in court all the time.
That's right.
Well, John, I've really enjoyed this conversation. I knew that I would.
Me too. This has been great.
I appreciate you coming on. Any last words that you might have for the audience? Anything that comes to mind that you think would be good?
Oh, man. Well, so many things. That's always a hard one. First of all, thank you for having me. This is a real treat. Being able to talk about these issues to an audience that's interested is, I think, just so important, because an educated citizenry about this stuff is what makes sure the justice system works.
Yeah.
And that's very important to me. My government teacher was one of my most important teachers in high school, and I feel like what we do is like a civics class for the world sometimes. So Thank you for that. You will see over the course of your time parsing the paper, following true crime stories, all sorts of things in the viewing audience and listening audience, all kinds of wild, crazy, and heinous stories. Just remember, people are presumed innocent, and the government's got to prove their case beyond a reasonable doubt. So that's why I do criminal defense.
Yeah, we're very fortunate to have the jobs that we have, aren't we?
We are indeed.
Yeah, we're blessed. We're blessed. Well, John, thanks again. I've really enjoyed the conversation. We've reached the end of this episode. Thanks so much for listening. Don't forget to subscribe and keep sending in those questions. Remember, you can now text the show by clicking Text the Judge to send in your insights, your reviews, and your questions. I'll mention them during the break. We'll be back in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.